right, so um, today I'm going to be presenting to you a little bit about my Build a Business project and what I have come up with throughout the semester in terms of my Build a Business project. My name is Jack Perry, and well, I hope you enjoy. So, starting with the business vision, the type of business I have chosen for my business is a law firm. The industry description is the Office of Lawyers, and the NICS code is 541110. I chose this type of company because I would like to practice law when I get older, and I think it'd be very practical to devise a business for the type of business you want to get involved in later in life. The type of service my business would offer would be legal counsel for clients in both criminal and civil matters. I would describe my future clients as a diverse group of adults, which may come to us to resolve any matters that they have criminal or civil in their lives going on. As far as investors and raising social capital, my plan is to find about 4 to 6 practicing attorneys, including myself. Hopefully we would all invest what we can into the practice in order to raise the initial amounts of social capital. And then what we would do afterwards is we would find a private group of investors who we would offer shares of the company to raise the additional social capital in order to begin operations. I do plan on having a physical location, brick and mortar location. This will be our company headquarters. I foresee us only really needing one location. We will be able to conduct business via, remotely if need be. We definitely have a business plan for that, but I would like us to have one physical location somewhere in Midwestern America, and we've actually decided that Indianapolis, Indiana would be the ideal spot for our business. My business, if functioning to its full capacity within the first 2 years, we plan to have between about 50 or 60 total employees. We would have 4 to 6 practicing attorneys, including myself, 2 IT specialists for the firm. There would be 2 operations managers per department for both the criminal and civil department, for a total of 4 for our firm. And then each lawyer would have 1 legal secretary and the option to hire 1 paralegal. And so that could be from about anywhere from about 4 to 12 employees. And then finally, each attorney will have their discretion of having a combination of up to 8 bookkeepers and record clerks. So obviously there's a lot of variability. We could only have 30 employees. We could have closer to 80. So 50 to 60 is just a rough estimate, but that's where I assume the average will be. And that's what I expect for our first 2 years. Moving on to business formation, the name of our business will be Midwest Legal Specialists, LLP. This name signifies that the business will operate, at least in its conception, on a regional basis, that is out of the Midwest. And the name also suggests not only proficiency in legal consultation, but specialized counsel by members with expertise in different fields of law. So we really try and offer a holistic and copious approach to the legal sector. So the type of business we would obviously advocate for would be a limited liability partnership. The reason for this is for 2 main reasons: tax implications and liability. First off, the tax implications of us forming a limited liability partnership would allow taxation to pass through our entity and just be taxed on the individual partners rather than taxing the business as a whole. That would be beneficial for us in order to maximize our profits. In addition, limited liability partnership would give partners a liability shield that would shield them from the liability of, negligence or tortious behavior on behalf of another partner. So under a limited liability partnership, personal aspects of a specific partner will be protected from being seized unless that partner is directly responsible for, the suit being brought against to recover damages. I plan to form our business in the state of Indiana, out of Indianapolis, as I have said. The reason is Indiana has relatively reasonable filing requirements and taxation in the state that is relatively favorable to our business. Basing the company out of Indianapolis will provide a central Midwestern location for our business to maximize connections and to maximize our profits. The name of the business is available in the state of Indiana, and I know this because I searched a government database that had all business names registered in Indiana, and Midwest Legal Specialist LLP was not registered. Furthermore, since our LLP would originate as a domestic LLP and not a foreign LLP, we would only have to file an articles of LLP articles of registration for a limited liability partnership with the state of Indiana. This document would contain, but not be limited to, the name and address of the limited liability partnership, the names and addresses of each partner, and the purpose of the business that the LLP would be engaging in. And like I said, this is the only form that we would have to fill out, so that's definitely favorable for us. And then I want to touch a little bit on lawsuit liability in terms of our business. Because our business is being created in and operating primarily out of Indiana, we would be responsible for any injuries we cause or any liabilities we fail to pay off in the state of Indiana. In addition, we don't want to just limit our business to Indiana. We want to keep our clients, we want to have clients from outside the state of Indiana, and so we would try and maintain business with clients from outside Indiana. The threshold for us being liable to any particular client in a different state is if we had minimum contacts with the resident in the state, an ongoing business relationship. So we could be held responsible in another state if we were to found to have held minimum contacts with a resident. And then in addition, finally, we could also be prosecuted in federal court under diversity of jurisdiction for a plaintiff from another state if the monetary cause they're seeking is in excess of $75,000. Moving on to torts. I do want to clarify that as a law firm, we will have a heightened duty of care in some instances. This isn't necessarily negligence per se, but there are other instances of negligence that could come into play into our business as a result of us not living up to that heightened duty of care. So we really have to make sure that we are living up to that heightened duty of care. And that heightened duty of care will apply to all clients, and it means that we must conduct ourselves in a way that meets the standards of a reasonable and skilled person within the legal profession. As a result of passing the bar exam, lawyers are automatically held to a higher standard of conduct and must act in a way that is consistent with their knowledge of the law. Negligence in terms of a law firm concerns legal malpractice that can suffer harm or that can cover a wide range of outcomes. Essentially, all these outcomes will cause a client to suffer harm or leave them in a less advantageous spot for an outcome than could have been reasonably expected in the case they're hoping to have decided. Therefore, negligence can be manifested in many ways, but some of these instances include, but are not limited to, inaccurate billing, missed deadlines, settling without a client's consent, failure to communicate with a client or clients, inaccurate legal advice or incompetent drafting of legal documents, and stealing or losing a client's money, among other things. So 2 potential scenarios that could leave the business liable for negligence would be settling without a client's consent, so in this instance, the lawyer would be responsible because they have a legal duty of care on behalf of the law firm to act in the most advantageous way possible for the clients. If the client believed their best outcome was through litigation, then obviously settling would not be a route that we wanted to take. In order for the client to prove that there was negligence, they would have to have proof of tangible damage or harm as a result of the negligence, and that our negligence was both the actual cause, meaning that the negligence caused the damages incurred, and the proximate cause of the damages, meaning the harm that resulted from the negligent behavior could be reasonably assumed. One way this could be evident is if the amount we were seeking to remedy was not sufficient to cover the losses that the plaintiff had incurred. Another situation is when somebody offers inaccurate legal advice to plaintiff. Obviously, we have a heightened duty of care to act within our legal expertise, and if we knowingly or offer advice that doesn't live up to that standard, then we would be negligent because that would most likely inform the client's conduct going forward in their case, and most likely leave them in an undesirable position for the outcome of their case. Once again, there would have to be a physical manifestation of the harm occurred, and it would need to be proven that the negligent conduct was both the actual and proximate cause of the harms or the damages that were incurred. So as a law firm offering legal counsel, we will not have product liability claims brought against us or any strict liability because we just simply do not have any products to offer. Moving on to intentional torts, there are plausible instances in which an intentional tort could come into play. The first of which being defamation of character by an employee or a lawyer associated with the firm in regards to a client. This would most likely result from an employee or an attorney who is closely working with a client. They are able to come up with the details of the case, and they're able to construe it in a way that is incorrect and subjects the plaintiff to defamation of character and a loss of reputation. I do want it to be noted that in order for the defamation of character to be proven, it has to be that an employee has made an untrue statement of fact that is not in opinion, and that it must be published, meaning that the statement is written or said, it is heard by the plaintiff and the defendant, and is communicated with the plaintiff. And it must also injure the plaintiff's reputation by exposing the plaintiff to hatred, contempt, or ridicule. Obviously, in this type of situation, they would have to prove that there was some sort of severe manifestation of emotional distress, and in the state of Indiana, there has to be a physical manifestation of an intentional tort. So that would be very important for the plaintiff to try and prove in court, and for us to try and disprove in court. Another tort that could arise is the infliction of intentional infliction of emotional distress, and that would be an instance in which we would take some sort of information from the case, or we would give something to the client that would make put them in a less advantageous position in their case, and would most likely cause them some sort of severe emotional harm that was intentionally intended by either one of the lawyers and the employees with the firm. Once again, this would have to have there would have to be proof of physical manifestation of this severe, and they would have to prove that our conduct as a firm was extreme and outrageous. Moving on to contracts, there's 4 very standard types of contracts that I just want to briefly cover. We have a standard bilateral employment contract between one party being us, the employer, most likely represented by the lawyer seeking an employee, and the other party being the applicant who is applying for a position within the firm. The purpose of this contract would be to clarify the terms of the agreement for employment. The terms to be negotiated would be the official title and position within the firm for the employee, the amount of initial salary, the years decided to work, and whether or not the employee has incentives or bonuses for performance and or tenure. The contract will also disclose a number of provisions that the employees must agree to. Provisions would include agreeing to dress professionally, i.e. courtroom dress, agreement to comply with HR procedures, agreement to a background test and a reference call, and an agreement not to compete with our firm if the employee decides to move to another job within the field. The contract will also outline our policy for dismissal of employees, which is a 3-strike policy that aims to provide discussion and constructive remedies before an employee is terminated. Another type of company or contract that we would have would be a bilateral provider-client contract. The parties would obviously be the provider, represented by the lawyer or law firm, and the client or clients, represented by the people seeking restitution in court. The purpose of this would be to distinguish the terms in the exchange of promises on behalf of both parties. The lawyer would pledge his or her services of legal counsel for the client or clients in their upcoming case. The lawyer would pledge to consult the client with any decisions pertinent to the case, to offer advice according to the lawyer's legal expertise, and promising to uphold the standard in all matters relating to the client's case. In exchange, the client would agree to a secrecy clause to not disclose any details regarding the case or the strategic plan of attack. And finally, the client would agree to pay the sum of the lawyer's fees and operating expenses incurred. This sum would be estimated based on the case and desired outcome prior to commencement of services exchange, but we estimate that this is only an estimate and that the cost may vary considerably. A third type of contract we would have is the contract for the leasing or purchase of a property. This contract that I've outlined details a lease, but a very similar one could be outlined for purchase as well. So the two parties would be our firm, and the other party would be the landlord leasing the property. The purpose of the contract would be to differentiate who or would clarify the terms of the leasing of the property, what we're paying, how long we're going to stay there, et cetera, et cetera. The landlord would provide the property where the firm will be located, the maintenance necessities to facilitate day-to-day operations, i.e. custodians, and any repairs incurred by damage to the property unless the damage was self-inflicted. We shall provide a monthly rent fee to be agreed upon by the parties. We will promise not to breach the lease by leaving the premise before the lease's conclusion unless eviction necessitates early removal from the premise. In return, the landlord shall promise not to evict us from the property. Gross negligence or failure to pay would nullify the prior cause. And then the final contract that we would have would be an advertising contract. The purpose of this contract would be to clarify the terms of advertisement that we're agreeing to with the advertising company. And then the two parties involved would be our firm and the advertising agency. The advertising agency could be TV, radio, billing, not billing, billboards, really any of those. The specific terms to be negotiated would be how much the advertising would cost, the duration of the ad itself, and the duration of the advertising period. The advertising company would pledge to run our ad on their platform for a specific time period, i.e. a month, a week, a year, etc., that will be agreed upon during negotiations. In return, we will pay the sum that we have agreed upon, either in one payment or installments, whichever is to be agreed upon. Moving on to intellectual property, I just want to briefly talk about patents, copyrights, and trademarks. While patents would certainly be important to any product-based company, we are a service-based company and don't have any products to protect, so therefore we would not be using any patents in operations. We could potentially use copyrights to protect an expression of ideas, either in the form of, this would most likely manifest itself in some sort of legal document in which a judicial theory or legal practice that has not yet been pioneered is being explored, and we would essentially try and acquire a copyright on that to protect that expression of idea and to signify that it is unique to the lawyer within our firm and the firm itself. In addition, we would also want to have a trademark because it would allow us to distinguish our counsel from others. While we acknowledge that our company, or that many companies offer legal counsel, we believe we have a higher standard for our firm and we want to set ourselves apart. As a result, we would potentially want to establish a collective mark that is representative of our company, and this collective mark would most likely manifest itself in a logo. We have decided to come up with a logo. It is attached up at the top there, as you can see in the slideshow. Essentially, the logo is a white background with a black encompassing oval and black text. The letters M, L, and S are emphasized to really bring attention to our company, and our logo, simply put, spells out our name, Midwest Legal Specialists, LLP, encompassed within the oval. This trademark, based on my search of the USPTO website, is available to be registered as a federal trademark. This is incredibly important because it would allow us to protect our logo and prevent people from infringing upon it. In the case that someone used a similar logo that would cause blurring or tarnishment of our business and logo, we would be able to recover damages from the infringing party. My search process entailed a basic word search containing the specific name as well as any word related to our name, and my more detailed search included the same basic search for the name as well as more complex searches for the design to ensure that our design was not already taken as well. We would like to have a website. I think that would be very important for us. The domain we plan to use is available, and it would be MidwestLegalSpecialistsLLP.com. We would also want to have social media platforms, and our handle would be at Midwest Legal Specialists. This handle is available on Twitter, Facebook, and Instagram, the three social media platforms I currently envision for our law firm. And there are no businesses in Indiana or nationwide from my searches that indicate that there is any business that has the same name as ours. Moving on to agency, I just want to briefly talk about who would have implied agency real quick. In our law firm. Obviously, this would be very nuanced because of the, who works for who, and who's necessarily being employed by an employer and who's being employed directly by the firm. Nonetheless, we would all have a heightened degree of liability for, personal employees signing on behalf of us. If I were to have a personal employee sign on behalf of me with implied authority, my personal assets would be they could be seized if that's the case. So obviously, any employee working within under me that has my implied authority would be an agent with implied authority on behalf of our firm. Any other employee who has implied authorization to sign contracts on behalf of any lawyer in the firm, as well as the entire firm, is also an agent with implied authority. Employees likely to be authorized to sign contracts on behalf of lawyer will be limited to only employed legal clerks, paralegals, and legal secretaries. IT workers, bookkeepers, and operations managers will only have authority to sign contracts on behalf of the firm or a particular lawyer if given express agent or authority, not implied. In terms of a principal's liability for employees, this would be a kind of a nuanced thing. This has a lot to do with the fact that we incorporated our business as a limited liability partnership to limit liability. As I mentioned earlier, I would personally have personal liability for any employee who has my express, implied, or apparent authority. This would relate to, tortious behavior, criminal behavior, or contract signing, among other things. Not only would the firm's assets be liable to seizure, but in this instant, my personal assets could also be seized because the employee is acting on behalf of me specifically, not just the firm. An employee who is hired and working with another lawyer's express, implied, or apparent consent would also make the law firm liable for their behaviors if they created grounds for a lawsuit. However, in this scenario, my personal assets would not be able to be seized. It would only be the lawyer who hired that employee whose personal assets could be seized, although the business could still have their assets seized at any time. Finally, my business would be required to follow a handful of federal anti-discrimination laws, including Title VII, the American Disabilities Act, the Pregnancy Discrimination Act, the Equal Pay Act, and the ADEA. I would also be required to follow FMLA, and essentially all of these requirements would ensure that my business must not engage in any discrimination when hiring and conducting business on the basis of race, sex, ethnicity, religion, age, disability, or sexual orientation. I would be required to pay men and women equally and would have to allow up to 12 weeks of unpaid absences for my employees. In addition, my state of incorporation, Indiana, also has some strictly outlined anti-discrimination laws, and therefore I would have to comply with those state laws as well. I would ensure that my business follows these laws by implementing a non-biased screening on applications that focuses mainly on candidates' qualifications and not physical makeups. In addition, we would also institute a system for existing employees and employers to participate in to ensure that the firm functions equitably. Our HR department will attempt to handle all occurrences of discrimination while helping to resolve situations quickly and internally. The HR department will also be responsible for producing a biannual, meaning twice a year, seminars of promoting equity within the firm while straying away from discriminatory action. So that's just a little bit about my law firm and my Build a Business project. And I want to thank you guys all again for listening, and I hope you enjoyed.